All right, Mr. Ingleson, are you able to hear me okay?
I am, Your Honor. Good morning.
All right, good morning. I don't see Mr. Trozak connected yet, so I'm going to give him just a few minutes just to make sure there aren't any kind of connection issues or technological issues. So if you
All
could just hold on
right.
the line. If he doesn't sign in by 11:05, then we'll get started, okay?
Okay, sounds good.
Thank you.
Yep, yes. I'm sorry.
Okay, we'll go on the record. And this is Van Wormer versus Trozak. This is Emmett County case number 24181085553. I've been assigned to this case due to disqualification of the prior judge. And this was set for a status conference scheduling conference today. It was set for 11 a.m. It's now 11:06. We do have Mr. Ingleson present on behalf of the plaintiffs by Zoom. Mr. Trozak, who at least up to this point has been representing himself. At least no attorney has filed an appearance on his behalf. Has not signed in, so we'll go forward. Mr. Ingleson, I believe the court did issue a preliminary injunction in this case, so we are under some time limits here pursuant to court rules. Any suggestions you have for going forward with scheduling in this case to get it resolved?
Well, you did issue the ex parte hearing. We had a show cause on November 25, and Mr. Trozak missed that. But on January 3, he filed with the court, and we received a copy. I don't know what, sometime recently too. His response to that, which at least he contends or disputes it. I've not had any communication from him, so I don't know why he is not attending today. We would certainly like to get it before the court and afford him an opportunity if he wants to participate, if he has some defense to our seeking a preliminary injunction. I mean, my client obviously needs gas service to run furnaces, et cetera, in both the upstairs and downstairs units that they have. Would the court be able to simply set this again in a week or something to give him another shot at it? And by the way, he hasn't filed an answer to the complaint, but back to my suggestion, maybe give another week, we set it up again and give him notice again. And after that, if he doesn't appear, then I would be looking for a default judgment and a permanent injunction as part of that default judgment.
Okay. Well, I'm not going to be able to do that. I've got trials scheduled throughout the rest of the month. So as you're probably aware that, I have a motion week at the beginning of each month, and then I have trials scheduled in each county.
I do.
For the rest. So it would be, early February, probably. I do have a mid-month motion day. I could try to get it scheduled for another status conference.
Okay.
Otherwise, it would be early February, and I don't have an objection to doing that. And then at that point, if you want, it'll be up to you, obviously, if you want to enter a default. If he doesn't appear, I'm sure it would be appropriate at that point. The only thing I want to clarify for the record is there was an ex parte motion for a TRO, which the court signed. The show cause was, in my view, pursuant to the court rules, a show cause for why a preliminary injunction should not issue off of the TRO. And
True.
so
I agree. Go ahead.
Yeah, so I'm viewing it as there is a preliminary injunction in place because Mr. Trozak, although he did apparently file some type of written response, did not appear for that. So in my view, we do have a preliminary injunction in place, so it would be a matter of setting some dates. I don't know if there's factual disputes here that would have to be resolved, assuming that Mr. Trozak does decide to participate and defend, or whether it would be a matter of default, but I guess we can address that at the next hearing.
Okay.
So
if you can do it mid-month, that would be fine, Your Honor.
Okay, so I'm just going to indicate for the status conference order that Mr. Trozak did not appear, and the court is going to set it for one more status conference at its next available date. We'll get notice of the date and time of that out to all parties, and then we'll go from there. Anything further that you want to address to the record today?
Nothing else. Thank you.
Okay, and I'll just indicate we're concluding the hearing. It's now 11:11 on my clock, and I still do not see Mr. Trozak in the Zoom waiting room.
Right.
So you're free to disconnect. Thank you.
Thank you. Bye.
All right, looks like we've got everybody connected. So we'll go on the record here. This is People versus Kyle Swank. This is District Court case number 2543403-SD-3. I'm presiding over this case on behalf of Judge Hesselink. And if I could have both counsel put your appearances on, please.
Good morning, Your Honor. Aaron Fortier on behalf of the people.
Ms. Bailey Quick, your microphone is not working.
Can you hear me now?
Yes, thank you.
Okay.
Go ahead.
Miranda Bailey Quick on behalf of Kyle Swank.
All right, we're on the record here today. It's my understanding, Ms. Bailey Quick, that your client is going to enter a plea today. Is that correct?
That is correct.
Okay, can you tell me your understanding of the terms of that plea agreement?
Absolutely. So Mr. Swank will be pleading guilty to operating while impaired for dismissal as an added count 2 for dismissal of the original count 1, operating with a high BAC.
Okay, and that's going to be a 93-day misdemeanor impaired?
Correct.
Okay. Mr. Fortier, is that a correct statement of the plea offer by the people?
It is, Your Honor.
Okay. Mr. Swank, have you had an adequate opportunity to speak with Ms. Bailey Quick about this plea agreement?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, it is.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Swank, you understand that by pleading guilty to this charge, that the maximum possible penalty you can face would be up to 93 days in jail and or a $500 fine?
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm sure Ms. Bailey Quick has gone through those with you, but I'm going to go through them with you again here on the record. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, I do, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty today?
No, Your Honor.
Has anyone promised you anything other than what we've said on the record?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you entering this plea because you are guilty of this charge?
Yes, I am.
The information I have indicates that this incident happened on December 26th of 2024. Is that the correct date?
That is correct.
Okay. On that date, had you been consuming alcohol?
Yes, I did.
After you consumed alcohol on that date, did you operate a vehicle on Charles Brink Road here in Otsego County?
Yes, I did.
At the time that you were operating that vehicle, had you consumed enough alcohol that it impaired your ability to safely and normally operate that vehicle?
Yes, it did.
Excuse me.
All right, thank you. Mr. Fortier, are the people satisfied with the factual basis?
Yes, Your Honor.
Ms. Bailey Quick?
I am, Your Honor.
Mr. Fortier, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
I'm unaware of any, Your Honor.
Ms. Bailey Quick, are you?
I am not aware of any. I will just disclose to the court. I just recalled, there was conversation that, I did discuss with my client that Mr. Fortier and I, talked about that it would just be costs and fines, and, that's the only other conversation I had with my client.
Okay, Mr. Fortier, a couple things to address on that point. Number one, you would have the right to have your sentencing hearing before me as the judge, because I'm the judge that's taking your plea here today. Our intention would be to set this for a sentencing hearing before Judge Hesseling, who is the presiding judge over this case. Do you have any objection to having your sentencing before Judge Hesseling as opposed to me?
No, I do not.
Okay. And then, although you may have had discussions with Ms. Bailey Quick and even with the prosecutor regarding a potential sentence in this case, you understand that I'm not making any representations as to what your sentence would be and whether or not it would be limited to fines and costs. You understand that?
I do, Your Honor.
Does that information change anything about your willingness to enter into this plea agreement today?
No, Your Honor.
All right. Mr. Fortier, do you agree then that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Ms. Bailey Quick.
I do, Your Honor.
The court finds, Mr. Swank, that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of the added count 2. The court will accept your guilty plea to the impaired charge. The court will set this for sentencing on February 20th, 2025 at 9 a.m. You'll be provided written notice of that date and time along with your attorney. Make sure that you stay in touch with Ms. Bailey Quick prior to that so that you're prepared to go forward on that day, okay?
Thank you.
Mr. Fortier, anything further that we need to address on behalf of people?
No, Your Honor.
Ms. Bailey Quick.
No, thank you very much for sitting in today, Your Honor.
Okay, no problem. Thank you. All parties are free to disconnect on this file.
Thank you.
This concludes the court's morning docket.